Hi, I'm Neidhardt.
And I'm Laina Poon, and we are here to present to you the audit that we worked on, sex offense cases. Some victims and their cases may be harmed by gaps. So there are four key takeaways from this presentation. First, most sex offense cases reported to the King County Sheriff's Office drop out early in the criminal justice process. This is a function of the winnowing effect the system has as it narrows down which reported cases meet the criteria for prosecution. Second, some victims may miss connection to vital services like support advocates because of process gaps that we'll explain later in the presentation. Third, cases take a long time to resolve because of factors like increasing caseloads and complexity, as well as limited resources. And lastly, we found that better data could identify inequities in case outcomes and strategies for improvement. We'll use the icons you see there at the bottom of the screen throughout the presentation to help orient you as to whether we are primarily talking about the King County Sheriff's Office or the Prosecuting Attorney's Office. And to give you a heads up, I'm going to talk about data to give you some information about how cases progress through the system, and then we'll focus on impact on victims and recommendations to improve their experiences. Over the past 4 years, the number of sex offenses reported to the Sheriff's Office has increased by 27%, from 676 in 2015 to an estimated 859 in 2018. Sergeants in charge of the Sheriff's Special Assault Unit noted that the increase in the number of reports doesn't necessarily represent an increase in actual sex offenses in King County. More likely, the trend reflects a greater rate of reporting. Cultural changes, including the Me Too movement, have encouraged more victims to come forward to law enforcement. In addition to the greater number of cases reported, cases have become more complex and time-consuming to investigate with the increased prevalence of digital evidence, such as cell phones and social media. People report a broad range of incidents, including crimes like rape, child molestation, and indecent liberties, which means non-consensual sexual contact that doesn't fall into the category of rape, and both adult and child victims and suspects. Some reported offenses turn out not to be crimes, either because an incident happened that was not criminal or an accusation was determined to be unfounded. The sheriff's policy is to take every sex offense report at face value without judgment of the victim. I'll briefly explain the criminal justice process for sex offenses to give you some background for the next piece, which will be data on how cases progress through the system. The process begins when a victim or some other party reports a sex offense to law enforcement. And while it's not pictured in this graphic, patrol deputies are often the first to respond and take an initial report. And this will be important later. A detective may be assigned to investigate a reported offense. Then the LE, or law enforcement agency, may refer the case to the prosecuting attorney's office. King County prosecutors receive case referrals from the Sheriff's Office, as well as the 37 other law enforcement agencies in King County. Once prosecutors receive a referral, an attorney who specializes in special assault cases reviews the information and decides whether to file criminal charges or to decline the case. After prosecutors file a case, they can resolve it either through negotiating a plea agreement with the suspect's defense attorney or by trial. Okay, here we go with the data. Over the 3.5-year period we reviewed, 2,571 sex offenses were reported to the Sheriff's Office. And to cut to the chase, only 162 of these reached a felony conviction. So why was this? I'm going to walk you through what we found by analyzing data from the Sheriff's and the prosecutor's offices. And this is the first time these data sets have been connected to get a full picture of sex offense case investigation in King County. First, about half of cases don't get assigned a detective. While some of these cases are not eligible for SAU investigation because they didn't happen in King County or were too long ago to prosecute, there are still victims in this pool of over 1,100 cases that would benefit from services like counseling and help getting a civil protection order even without further involvement from law enforcement. And we'll talk more about that later. Next, detectives referred less than a third of reported cases to the prosecutor's Special Assault Unit. A case might not progress at this stage if there's no suspect or if there's no evidence that a criminal act occurred. Prosecutors filed 10% of the sex offenses reported, or 252 in Superior Court. The main reason so few cases progress to this point is that prosecutors can only file charges if there is sufficient evidence available to support a conviction and if victims are willing to participate in prosecution. According to the prosecuting attorney's office, half of all the cases they decline to file are what's called statutory referrals, which are cases involving children that law enforcement was legally required to refer, regardless of whether there is actual evidence that a crime has been committed. And back to the bottom, in 6% of cases, or 162 of the 2,571 reported offenses, reached conviction either by plea or trial on at least one felony charge. This might sound like a small number, and indeed it may feel so to some victims. We compared King County's results to national statistics and found that King County's numbers did fall within the wide range of published conviction rates. Many factors play into the likelihood that a case will reach conviction, and the truth is that the criminal justice system is not the best or only system to help all victims of reported sex offenses. We make recommendations about ways to connect victims with support services, even if their cases don't progress all the way through the system, that Mia will tell you about in the next section. While relatively few of the offenses I just showed you resulted in a felony conviction, if we narrow the scope to just the cases where prosecutors felt that there was enough evidence to file charges, the conviction rate jumps to 65%, shown in the blue part of the pie chart. If we exclude the cases that were still open at the time of our review, shown in orange, the conviction rate jumps to 90%. And what this means is that for the cases where there is enough evidence to reach a conviction, prosecutors usually win. But in the majority of cases, this doesn't happen, as I explained before. Even though staff at both the sheriff's and the prosecuting attorney's offices are extremely dedicated to helping victims of sex offenses, the criminal justice process is not easy for victims. Mia will talk about some ways that King County can make it easier for people going through this process and provide more information on the outcomes of sex offense cases.
King County is a national leader in bringing together stakeholders to better support victims. The King County Special Assault Network brings together law enforcement, the prosecutor, hospitals, child protective services, and advocates. And one member that I want to highlight is the King County Sexual Assault Resource Center, or KSARC, which provides legal advocacy to guide victims through the legal process. They also offer counseling and help connect victims with other services like financial compensation and protection orders. As an example, they can help victims obtain civil protection orders to keep an offender away from them, even if criminal charges aren't pressed. These types of services can help victims in their healing process. As Laina showed before, most reports of sex offenses do not result in a conviction. And even for the cases that do, victims can still have struggles and needs that can't be addressed by the criminal justice process. Early connection between victims and advocates is important. Advocates stated that connecting with victims early in the case helps them provide support when victims need it and build trust that can help victims persist through the stages of the criminal justice process. But we found some gaps in early connection with advocates. For example, sheriff patrol deputies, who are often the victim's first point of contact with law enforcement, do not consistently provide information about KSARC or other services to victims. This process gap could prevent victims from learning about services available to them, particularly if these cases aren't referred to detectives. And the available materials for victims are unclear. To illustrate that, this is the sheriff's current victim services handout. It contains information that law enforcement is required by state law to provide victims of violent crimes. This handout is confusing for both patrol and victims. For example, the current handout is labeled for domestic violence victims, so it isn't clear to patrol officers that the information could apply in other types of cases, including sexual assault cases. Also, key resources are not easy to find on this crowded sheet. For example, CaseArc's information is buried at the bottom of the page without context about what they can offer. So we made a recommendation to the sheriff to develop a checklist for responding to sex offense calls and train officers on it, and to work with CaseArc to develop a new sex offense specific handout for victims that's user-friendly. Patrol sergeants felt that the checklist and handout would be helpful for both their officers and for victims. Now, on the prosecutor side, the prosecutor does not provide advocacy information to victims until the filing of the case. Some cases are filed within a day or two, but depending on the filing backlog and the characteristics of the case, the filing decision could take up to several months from the time of referral from law enforcement. The prosecutor receives cases from the sheriff's office and 37 other law enforcement jurisdictions in King County. So a shift in its processes could better ensure that victims of cases throughout King County are connected with services, not just those victims in King County Sheriff's Office cases. So we recommended that the prosecutor provide all victims with advocacy information upon referral of the case, not waiting until filing. As a note, many victims may already be connected with an advocate before the referral to the prosecutor. But a process like this can help ensure that no victims slip through the cracks, but instead receive a quick connection to an advocate. Another reason that early access to advocates is important is because cases can take a long time to resolve. Of cases that reached a resolution in Superior Court, the majority took more than a year from initial report to conviction, and 12% took more than 2 years. Now, some factors influencing a case's duration are outside the sheriff's or prosecutor's control. Timelines can extend due to long waits for exam results, and also court calendars and case continuances, and other aspects of the criminal justice system. But limited resources and staffing can also impact case durations. The average sheriff detective handling sex offenses has 27 to 32 open cases at a time. In comparison, the Seattle Police Department's corresponding detectives have half that number of cases open at a time, about 12 to 17. Seattle sergeants stated that they get concerned about investigation quality if caseloads get above 20 per detective, as the sheriffs regularly are. For the prosecutor, filing is a backlog due to limited filing positions, which require a high level of expertise. The prosecutor recently began tracking its filing backlog and used that data to help obtain resources from a state grant to add a temporary part-time filing attorney to help address this heavy filing caseload and backlog. And for the last part of this presentation, we're going to shift gears to talk about case outcomes. The prosecutor does not collect race data on victims or defendants, making it difficult to assess any disproportionate impacts of charging decisions. We didn't have sufficient data on victim race, but we obtained defendant race data from the Department of Public Defense to explore potential race disparities in trials and plea agreements. And to reiterate, a plea agreement is an agreement between the prosecutor and the defender outside of trial. In our analysis of this subset of cases, we found a correlation between defendant race and type of outcome. That cases involving white defendants represented by public defenders were 10% more likely to resolve through a plea agreement instead of a trial, compared with cases for non-white defendants represented by public defenders. Now, this analysis is limited because it doesn't account for some factors that influence the prosecutor's charging decisions when offering a plea, like victim preferences. But it represents something the prosecutor should look into to see if their processes, such as the content of the initial offers to defendants, are leading to disproportionate outcomes. So we recommended that the prosecutor collect and track demographic data about defendants and victims, use this information to assess outcomes, and then develop plans to respond to any identified disparities. The prosecutor stated that they are exploring potential sources of information on defendant and victim demographic data to begin this work. So to recap, most cases that are reported to law enforcement drop out early in the process. Due to this and other process gaps, some victims may miss out on connection to services. And the cases that do progress can take a long time to resolve. Finally, better data could help identify inequities in case outcomes. Our full report is available at our website, and it provides more information and recommendations than we were able to cover in this presentation. Thank you for watching.